Being streamed live on the web. Now we have cameras as well as audio. And if council would first identify themselves by saying their names for the record together with the party you represent, starting with the appellant.
Connor Cobean on behalf of the appellants, the state of Maine, the Maine Department of Corrections, and the Maine Correctional Center.
And I am attorney Carly Cosgrove on behalf of the appellee Josh Rinaldi.
Thank you. Counsel, if you're ready to proceed, we'd be happy to hear your argument.
Madam Chief Justice, and may it please the court, Josh Rinaldi slipped on ice while walking outside at the Maine Correctional Center on a paved outdoor thoroughfare known as the Runway. The facts are not meaningfully disputed, and this appeal therefore presents two questions of law concerning the public building exception to governmental immunity under the Maine Tort Claims Act. First, is the MCC a public building? And second, is the runway an appurtenance to a public building? A ruling in the state's favor on either issue is independently sufficient to vacate the Superior Court's order on the parties' dueling summary judgment motions, and I will address each issue in turn. This court's analysis in Rodriguez leads to the conclusion that the MCC, a prison, is not a public building under the MTCA. Rodriguez highlighted that a public building is one that provides services to the people on a business basis and is a place accessible to members of the community. And although MCC does provide a public service and function, that function does not involve inviting the people in or the public in on a business basis, but rather separating the people from those who have been convicted of crimes. Furthermore, the public's access to the prison is highly prescribed, limited to family, friends, professional visitors upon prior written request and application. Thus, given that immunity is the rule and exceptions are to be narrowly construed, the MCC is not a public building under Rodriguez. Turning to the second question, the runway is not an appurtenance to a public building under the three-part definition of a fixture used by this court. Namely, is it physically annexed to the property? Is it adapted to the property or to the realty? And is it intended to be irremovable from the realty? In applying these factors, it is helpful to make clear what the runway is. It is a paved road running down the center of the facility that serves as a primary walkway for foot traffic and occasional vehicle use. The parties agree on these facts. With this in mind, the three factors all weigh against the runway being an appurtenance. First, like the parking lot at issue in Klein, the runway is a paved surface that, although contiguous to MCC buildings, is not connected to or incorporated into them in any way. Under Klein, then, the runway is not physically annexed to the MCC and therefore cannot be considered intended to be irremovable from the realty. Finally, there is nothing special about the runway's pavement that adapts it to the realty. This is unlike McDonald, where the brick-paved plaza served the unique needs of the police department by making the roof of the lower section of the building accessible for foot traffic to the upper sections. The plaza was necessary for the police headquarters to function, for people to get in and out of the building. Here, even if the runway were not at MCC at all, people could still walk from building to building. They would just be walking on the ground rather than pavement. The buildings would still be accessible. For those reasons, the decisions in McDonald and Klein counsel that the runway is not an appurtenance to a public building, and so the state asks that the court vacate the Superior Court's decision. And I can now answer any questions that the justices have.
Go ahead.
In a summary judgment record, this is a summary judgment case. Is there anything that tells us, we have some photographs here and some other things, and it appears that the asphalt walkway is contiguous to the building. It meets it at some point. Is there anything in the summary judgment record that tells us how is it hooked on by some construction means, or is it just bumps up against it, or is the record void about that?
The record contains the photos. The photos indicate that the pavement comes up and abuts the buildings, but it does not indicate whether it is.
Who has the burden of showing us that it's annexed to the building?
In general, that's the non-prevailing party that the court takes the facts in the light most favorable to. Here, I don't know that really becomes an issue because the facts are largely agreed upon.
In Cyril, when we talked about annexed, we said physically annexed, at least by juxtaposition. In other words, we didn't say that it actually had to be in some way mechanically or otherwise affixed to the building, but that it was annexed at least by juxtaposition. Isn't this at least by juxtaposition?
Certainly, Your Honor. There is juxtaposition here. They are contiguous. That being said, there is a line of cases, including Klein, involving pavement that is juxtaposed next to buildings where they have not.
Well, but Klein involved a parking lot that, in fact, the building that the person was going to was across the street, as I recall. And it's not captured in the same way as this is it?
No, that is different. I would turn the court's attention to Campbell, which is a District of Maine case that involved a fire lane immediately behind an apartment building. The opinion is not perfectly clear, but that fire lane appeared to be juxtaposed behind the building in a way that is similar here.
Counsel, can I just, on that point, can I just clarify something? We're talking about juxtaposed, we're talking about annexed. This, based on what I can tell from the photograph and the diagram, this seems like a separately standing piece of pavement. It doesn't actually touch the building, does it?
The photos speak for themselves, and the record is what it is. It is the state's position that the record showed that the pavement is not connected to the buildings, that the pavement could be removed without damaging the buildings in any way, which is a factor that the courts consider under Searley in deciding whether something is physically annexed.
So is the lack of a connection between the two, is that dispositive? Is that end of the road here, so to speak?
It's not dispositive, but it weighs heavily in the analysis in that that shows that you could remove the pavement without impacting the building, and that the pavement is not incorporated into the building.
So someone could take a jackhammer and jackhammer up the asphalt and the building would still be okay?
Not only okay, but perfectly functionable and accessible.
So it's more like a fire lane than it is the front steps.
That is correct. And steps are instructive because in many buildings, the entrance to the building is maybe several feet off the ground, so the steps serve an incorporated function that they allow the building to be accessible. That is sort of a classic example of an appurtenance.
But the runway is incorporated to the extent that it facilitates access to the buildings that are adjacent to it, correct?
I'm sorry, could you repeat the question?
I said the runway is incorporated or adapted to the buildings that surround it because it does facilitate access to those buildings, does it not?
It does service access to those buildings, but is distinguishable in what is considered adapted if we look at McDonald, where in the absence of the brick paved courtyard, which is on top of the roof of a different part of the building, you would not be able to get into the lobby of the police department. I mean, generally speaking, one does not walk on the roof.
Could the people here, the inmates here, Mr. Rinaldi or other inmates, get back and forth to chow, et cetera, without crossing through the area that they were crossing through?
That is the most convenient way of getting from point
Well,
A
it's how they're told they have to do it, right?
That is correct, but they could make the same trip without the pavement.
If the asphalt was removed and it was a gravel path or a dirt path or mud path, would they still be able to access the building?
Yes.
But adapted is an interesting word here, and it's subject to interpretation. One could argue that when they put in this pathway, it went specifically off the branch of the road right up to the door, and someone could say that that was adapted to make that connection to the building. Is that too far off the definition of adapted?
Yes, Your Honor. I believe if we include that as being adapted to the realty, it opens up a very large number of walkways you can imagine in this state on public facilities, public campuses that are paved walkways between buildings, which here, up till now have not been considered appurtenances.
To constitute a public building, does the entire building have to be open to the public? In other words, does the public have to have the right to wander through the entire building? The reason I ask is that the Portland Police Department was considered a public building in McDonald. Admittedly, it wasn't a contested issue, but that building has a reception area that is open to any member of the public, and across that to get to that public reception area, one has to go across the plaza that was the appurtenance in McDonald. And in this case, doesn't the Maine Correctional Center have a public reception area comparable to the police department?
That is correct, and the lobby is mentioned in the record in the visitation policy. That being said, and to answer your initial question, no, the entire building does not need to be accessible to the public. As noted by the Superior Court in its opinion, there is a spectrum between fully closed off and fully open. Here, we are very, very, very much to the side of fully closed.
Well, except that the prisoners themselves are not employees of the state or employees of the prison. I mean, they are, in that sense, members of the public. They are not free to go or anything else. They are in the custody of the state. Nonetheless, wouldn't something like employment status, if it's only open to employees, for example, of the state or of the public entity, wouldn't that make a much more sensible place to draw the line rather than trying to figure out just how much of the space can be entered by the public?
It's not solely a question of how much of the space can be entered by the public. And to touch on that issue for a second, and to distinguish it from the police department, you can imagine a number of reasons why one would go to a police department for services that one would not go to a prison. You could go to report a crime, to give a statement, to get fingerprinted for a background check, to pay a citation. I think the public at large thinks of police stations as places that are available in times of emergency to go and seek.
But to the chief's point, aren't inmates member of the public? Are we saying general public, and they're not members of the general public because they're incarcerated? If we conclude that inmates are members of the public, doesn't that make it a public building?
In addition to visitors and everything else that do access the premises.
I don't know that the residents should be considered members of the public. They
Really?
occupy a distinct space here, clearly.
Well, what are they?
What was that?
You said they're not members of the public. Who are they?
They are people who have been committed to their...
Well, let's look at a school. These days, schools are public buildings. Do you agree?
Yes.
They're pretty much locked down these days, aren't they? It's hard to get into a school, and they don't let the general public in. So why are they public buildings?
Well, the students come and go each day.
So if a prisoner could come and go, that would make it a public building?
Well, some prisoners do, before you answer, some prisoners do come and go if they're on work release, do they not?
That is correct.
And to the extent, are you saying that to be a public building, you have to allow the entire public to come in? Because there are, as the chief noted, visitors who come in to see the individuals who are imprisoned there, correct?
I'm sorry, what was the last part?
There are individuals, often related, sometimes not, just friends, who come to visit the facility to see the people who are incarcerated.
That is, yes.
So you're suggesting that the entire public has to be allowed access to the building for it to be a public building?
No. Again, it is a spectrum. And our position is that this is very far to the side. And also, this is just one of the factors, another factor being the nature of the services provided. Whereas here, you don't come to the prison expecting any sort of service. You can walk into the lobby, but unless you have made a prior written application to visit, that is the extent of the business you can get there.
Thank you, counsel.
Time is
It is.
out.
Thank you. Attorney Cosgrove.
Thank you. May it please the court. While this case analyzes the applicability of the Maine Tort Claims Act public building exception, it is not a case that is expanding on the immunities or expanding the case law of the Maine Tort Claims Act. It is a factual determination made by the trial court after analyzing and looking through and applying the specific facts to the specific case law. First, the Maine Correctional Center is a public building for purposes of the Maine Tort Claims Act. The law court has suggested as such, and because the public is allowed to enter, whether on a restricted basis or not, it classifies as a public building. Second, the runway is an appurtenance to a public building. The law court found, after comparing, analyzing, and looking at the facts with the relevant case law, that the runway, which facilitates all prisoner movement, supervised movement around the prison, and thereby facilitates the function and the nature and the necessity of prisons being supervised.
Well, let me stop you there because the green light's on and you just used the word function. We don't use a functional test. We use a fixture test. And so don't we have to focus on whether this is a fixture? And normally pathways, sidewalks, lanes aren't considered fixtures, and we're supposed to construe these exceptions to immunity narrowly. So how do we get around that?
So you're correct. Yes, that's a fixture-based approach, which analyzes how it's adapted to the realty, which analyzes if it's physically annexed, and it analyzes whether it's intended to be irremovable. The function of the Maine Correctional Center goes towards that adapted to the realty factor, where the prisoners are required to be supervised while moving through the prison, but it's the only way they can move through the prison.
So here's a hypo for you. School building, it has a paved pathway to the football field. The paved pathway is connected to the school building. It's right contiguous, juxtaposition, and the way that you get to the field is on this pavement. Is that a fixture?
Well, I think here that would be, if the law court hasn't specifically ruled, that specific hypothetical would be subject to the same analysis that the runway in the courtyard, we should call it, it's more of a courtyard here, of the Maine Correctional Center was. We would take the facts you described, so the specific facts of it being juxtaposed to the football field, and run that through the same analysis.
Is it significant what you just said, that it is in essence a courtyard, i.e. let's say it was a true courtyard enclosed on all four sides by the building? Does that matter if that it's a courtyard versus a path leading away from a door to wherever outside the building?
Yes, I believe that matters here because it describes how typically sidewalks, typically walkways, fire lanes, they lead from one destination to another destination. The runway acts as a courtyard here where it leads to every single building for prisoners to access. So that's how they get their food.
This really isn't a courtyard, is it? I'm looking at Exhibit A, and it's a sidewalk that leads to various buildings within a complex. When I think of a courtyard, I think of a quadrangle enclosed on four sides with a pathway through the middle. That's not what this is it?
So looking at the image, it does look like a paved pathway leading through. However, the area that is enclosed, it's completely enclosed within the prison.
Well,
and
it's enclosed by the outer fence.
It is enclosed by
the... It goes around all of the buildings.
Correct. However, the inmates can only get to each building they need. They can only get to their required amenities, food, where they sleep, the medical building, by going through that.
But how is that different from a parking lot that's situated across the street from a school building, and you walk across the street and you start walking up the pathway to the school building and you slip and fall? How is that different from the runway?
In this case, it's different because in Klein, a parking lot is more akin to a walkway. Here, we have more comparisons to McDonald for the plaza. The plaza in McDonald was the only way that people could enter the department. Here,
it was a roof also, though.
It was built into the building.
Yes, and the runway is a little bit different where it's not physically built into. However,
can I just question on that?
Absolutely.
There's some in the previous questioning, it was brought up that the asphalt pathway doesn't actually connect with the building itself. Is that correct?
There's nothing in the record that says it does physically
that's
connect.
what I'm getting. And doesn't your argument slide into the function thing, saying it's unique because it's a lockdown situation, we've got a fence around it, and the function of this place is that this is the pathway they use to go to the door. Doesn't that slide you into the function of this pathway as opposed to the Cyril tests and the Klein tests?
I don't believe it does. I think and function may be the incorrect word to use. It's the essential nature, it's the integrated nature of this runway, this courtyard area, this large paved area that leads to multiple different buildings. It's more than a physical connection where it serves as a connection for these inmates to access everything they need. Without it, they wouldn't have that access. So it acts
The court below, the summary judgment court, seemed to put a great deal of weight on the fact that this is a lockdown facility. Is that, I'll ask you first if you agree that the court did focus on that, and if that's an appropriate focus in determining whether or not this is an appurtenance.
Yes, Justice Stewart focused specifically on the fact that this was a lockdown facility, but I think that goes more to the essential nature of the runway serving its purpose. It's completely enclosed by a fence, and if a fence doesn't prevent others from leaving, then the buildings do. So to exit or enter, you either need to pass through those locked gates or go through one of the locked buildings. Inmates do not have the ability to do that, so they are limited to moving around in the runway area. So while while there's no physical walls there, the locked gates and the buildings serve as a wall, kind of enclosing everyone, keeping them in that area, and that it goes towards the Searle test, the factor of adapted to the realty.
Could this pathway be removed without damage to the building? Could someone take a based upon the record we have here, which is a limited record, couldn't someone just take a jackhammer to that asphalt and chip it away and put in a gravel path or something else? That building's still going to be solid.
Yes, there's nothing in the record to say that it can't be jackhammered away. However, I think the essential nature of the runway and how it can't be removed goes towards essentiality, meaning it is in the middle of the facility and it gets its necessity and its functionality and its needs to be there. It's necessary because it's in the center of the facility as a whole. It allows them to traverse the facility and get around to get everything they need.
And that actually leads us into specially adapted to the purposes of the building. One of the tests, the third test. This is a pathway. It looks like a pathway. It's adapted as a pathway. Is there something unique about the building that it was adapted to other than the fact that it leads up to the door?
I think the uniqueness comes with the way that the prisoners need to be supervised at all times, but also they are controlled in their movement. And while that's not a factor, it goes towards the adaptation because the runway was specifically designed to facilitate their movement while facilitating supervision that's required for the prison.
That fits in under the language that we've used about being united and carrying out of a common enterprise, that it is equally as essential as the building to carrying out the common enterprise.
Correct, yes. I think that it goes right with that analysis.
So a path with the fact that there's a walkway to a building that somehow unites it with the building's enterprise?
No, it's this is well, yes, in a way, but the pathway here or the runway is more than just one pathway leading from one building to the next. It's the means of access for the prisoners to get everything that they need. It's contiguous to multiple buildings. It's juxtaposed to multiple buildings. And
so every public building that has a pathway leading to it, automatically that pathway has been adapted to the building? Sounds like what you're saying.
No, that's not what I'm saying, Your Honor. I believe it goes, there needs to be more. There needs to be something more there. Like Justice Stewart said in his order, the reading McDonald and reading Klein together, it's obvious there needs to be something more than just being contiguous to one building, and I think the runway meets that.
And what's the more?
The more here is the runway it serves as the access way by which inmates move through the prison. They can't access their amenities without it. They access it 5 to 6 times a day because it's so essential for them to be out there.
And I'm looking at language that we quoted in Cyril when we said the extent to which the owner has treated it as an essential part of the premises and the actual essentiality of it to the accustomed use or operation of the premises. Is that what you're talking about?
That's what I'm talking about, Your Honor. And directly on point with that is the runway was designed to facilitate this movement around the prison while letting the inmates get everything they need and maintaining the required supervision, remaining in the building.
Well, looking at this picture, the runway isn't very well defined. So, I mean, they could be walking 6 feet one way, 6 feet the other way. They could be, it's really crossing the grassy yard. I mean, what are we to make of the fact that it isn't very well defined what this runway is?
I think well, first of all, the runway, and it may not be in the record, but it's more of a term of art, as what the prisoners and the inmates and the personnel refer to the courtyard as. While there is a pathway running through it, it's much more than that. There's, as you can see from the photo, there's a field in the middle there. There's recreational courts. The inmates use the entire area of the runway for eating meals, socializing, doing some recreational activities such as running laps and that kind of thing.
So what are you saying is the runway? Are you saying that if he slipped and fell playing recreational activity that wasn't right on the narrower path, would that still be a part of the runway?
I'm not saying, I don't have an answer to that specifically. I think, again, the runway here, the area we're referring to of the runway is that access way, the walkway that he was on. However,
but they don't have to stay right on that runway to get from one place to the other, do they?
They do not. They, as you can see, there is a video in the record of my client slip and fall, and you can see multiple different inmates and personnel transversing around, and they don't have to stay right on that runway because the entire area, including that field, including those buildings, is surrounded by the fence. So that area you see in the middle that is directly adjacent to the runway, the road barrier itself is not fenced in. The entire area is fenced in, so it goes out towards where the buildings are.
So the record does show where the slip and fall occurred.
Yes, there is a video of where the slip and fall occurred.
I don't have the video in front of me, but I do have Exhibit B and C in front of me. Does that depict approximately where the fall occurred?
Yes, Your Honor. If you look towards the, it's towards the medical building, and it's where it's like a large Y area where the runway itself splits off, and then there's that center field. It happened right near I guess the apex of that Y.
So that's Exhibit C, I think.
Oh, yes, yes.
And it happened some, I don't know, some distance from the buildings.
It did happen some distance from the building, yes, Your Honor, but it happened right on the runway, which is what we're discussing here. It's the appurtenance to a public building.
Right, but the runway, just following up on Justice Connor's question, is it the paved portion that we're talking about, or that the fall occurred on the pavement?
The fall occurred on the pavement, yes. However, the runway is not confined to just the pathway. The runway is what is referred to by the inmates as whatever the general area.
The general area.
It is a term of art they use, yes, Your Honor.
Have we ever held that an appurtenant area that was not open to the public was within the scope of the waiver of sovereign immunity? In other words, the parking lot in Klein, the Plaza and McDonald, all open to the public, may or may not be appurtenances, but it strikes me that the runway is not open to the public. A member of the public cannot simply stroll onto the runway, I assume.
The runway does have its limited visitation policy. Specific allowed and permitted individuals are allowed on the runway, so volunteers and professionals, so social workers, doctors.
If I went out there, could I go onto the runway without asking or without any permission?
According to the record, no, you would not be able to. However, as the Chief Justice said, the inmates themselves are, considered public, and they access it daily. The employees access the runway daily, and again, limited volunteers or professional visitors, after they've been allowed and met that application to come in, they can access the runway when they need to interact with prisoners.
Our colleagues on the federal side interpret Maine law, and they make their observations, and they said in Ms. Kay versus Portland, Maine courts have consistently held that paved walkways, including sidewalks and fire lanes used for pedestrian traffic, are not appurtenances. Understanding that's sort of just, I guess you would say, dicta, or there's nothing in support of it. Would this mark a change from our existing jurisprudence if we were to say, yes, this asphalt walkway is in fact an appurtenance to this public building?
No, Your Honor, I don't think it would change that because, again, it is a specific factual analysis based off of the specific factors and characters of the runway itself. And by running through that analysis with the relevant case law, it was found it was appurtenance. So it keeps Maine law consistent. In fact, maybe finding that it is not an appurtenance because it meets that required test would actually change Maine case law. Thank you, Your Honor.
Thank you. Mr. Cobean, you reserve some time for rebuttal.
Yes, Your Honor.
Following up a little bit on what Justice Horton said and Justice Mead as well, I mean, does it matter that even if we viewed this as a sidewalk, does it matter that it's not a publicly accessible sidewalk? And I'm going to suggest to you public can be used differently in different means, but we know that the public as a whole can't just walk on this sidewalk. Does that matter?
Our position is that the entire facility is not a public building.
I understand that. So now I'm moving to the other aspect of it, which is the appurtenance aspect. Does it matter that it's not a public sidewalk for that purpose?
To the appurtenance analysis?
Correct.
I don't believe that it factors into that analysis, no.
Would this be an appurtenance if it had a roof over it?
Well, that is not this case. That applying the factors, the three-part factors.
That's why we're calling it a hypothetical.
If it has a roof over it, then it changes the adaptation to the realty element for sure. You could imagine that a roof would have to be secured to the buildings in a way that pavement is not, that it would be bolted in. And
Well, it doesn't have to be bolted in. It could be, it doesn't have to be connected to the building. I'm just saying if it was a walkway that had a roof, does that make it look more like a fixture? Or is it the connection to the building that would matter?
Well, you need all three factors. That maybe pushes the scales a little bit on the adaptation to the realty and the level of physical annexation. But here we do not have those elements.
It doesn't matter whether the walkway is paved, whether it's decking, or what it's made out of?
No, Your Honor, only to the extent that if it were such that removing it might injure the building, that would affect the physical annexation analysis. I see that my time is up.
It is. Thank you. Thank you, counsel, for your argument here today. As is our usual practice, we will be taking the matter under advisement and issuing a written decision in due course. It's also my understanding that Attorney Cosgrove and Attorney Cobean, that both of you, this is your first trip here. As is the tradition, we would ask you to come back and take the greetings of the court in our conference area with counsel who are accompanying as well, are welcome to come.